Hello, hello. All right, now it seems like everybody can hear me. All right, I should have a really good group today based on the number of responses I got. So can someone, Nazimi, can you say something to me? Oh, I know what I got to do. I got a lot of talk. I got a lot of talk. Hold on one second. All right. I thought I had allowed everybody to talk, but no, I have not. Now I have.
Can you hear me now?
Now I can. Yeah, I had to click another button.
The chat is disabled, so we cannot text.
Okay, that should not be. I can go in. What's really goofy is that I basically just,
I can see you and I can hear you, but I cannot chat.
yeah, I understand. I went in and basically copied a previous meeting, so all the other features show copied. But you're able to see my chat, right? When I send something to you guys.
Um, I don't see anything right now.
Let me try it again. I'm going to put something in the chat. Putting test.
Can you hear me okay, Joe?
I can. I can.
Okay, I'm noticing when I click on chat, it says chat
Okay, I
disabled.
saw. I saw test.
Okay.
Okay, me too.
Yeah, let me go into the Zoom meeting. I don't necessarily need you guys to be able to text me as much as I need to be able to send stuff to you guys.
Okay,
Because I'm going to do, this is going to be a lot of show and tell today. We're turning a corner on this case. And I am wanting to make sure that everybody is caught up. Because I have filled out, I've gotten a great response so far on the form fills. I have about, I don't know, last night when I went to bed, I had about 115. I think that number is bigger now. There's some more. I sent out a reminder last night. And I want to explain what that means to those who haven't been here before. And again, I'm expecting there to be a lot of folks who have not been here before. Nothing from me across the board so far.
Good afternoon.
Hey, good afternoon. Good afternoon. We haven't kicked off yet. We're waiting on everybody to get in the
Good
room.
afternoon.
Just waiting on folks to come in. Yeah, as of this morning, we have 128 entries on the. Make sure I've got everybody allowed to talk. I'm going to give everybody just another minute to get in. I'll be letting people in pretty much the whole time. I'm going to go over this. Uh, I'll call it a parallel approach to the litigation. And I want to do some screen sharing today. So hopefully you've got access to either, big enough tablet or computer screen that you'll be able to see what I'm sharing. I'm going to record this. So anybody who's worried about their ability to see, it's already being recorded. By the way, there's notes and it's being recorded. And I'll do what I always do, which is to send a video around and to post the video on the website that's made specifically for this case. All right, so it looks like we may have, I mean, there may be others that come in, that usually happens. They'll kind of straggle in toward the end. But again, for those of you who don't know me, I would find that to be unusual. I'm Joe Whitcomb. I am the lead counsel, founder of Whitcomb Selinsky PC, and lead counsel on this. I've historically called it a misclassification case. It's now more of an employment law case generally, but within a very specific subset. This case has to do with the government's what I would characterize as the government's illegal employment practices, to include misclassification, but there's been overtime theft, and I'm arguing for both misclassification and what I call constructive misclassification, and I'll go over what all of that means. And again, I want to thank everybody so far. I mean, it's just been an overwhelmingly positive response and really great information. And probably the first, and I'll just say that this was hopefully a function in part of good messaging on my part. The form is effective. People have filled this thing out, and we're getting amazing results from that. And I'm going to show you guys what's going to end up coming in your inbox here, and I mean in the coming days. I mean, my drop dead date, there's no like statute of limitations issue, but I am pressing really hard to have this done by the end of this month, to have everything signed and filed by the end of this month. So I'm going to show you guys what that's going to look like. So the forms that you guys completed, I pulled those into some software, and I've generated what's going to hit your inbox. The first is a sworn statement from you that lines up with the entries that you've put in the form. The second is what's called a standard form 95, which is the form that you have to submit to the government. And I'm going to try to give you guys a really down and dirty kind of law class. You guys have heard me talk before about the government's general immunity from suit. You can't generally sue the government unless there's some statute under which we can sue them. So we've sued them in the Court of Federal Claims under the Fair Labor Standards Act because that statute says that you can sue the federal government. Unfortunately, based on some case law, the current common understanding is that the only court in the country where you can bring that Fair Labor Standards Act or FLSA action against the government is in the court we're in, the Court of Federal Claims. The second prong that we're headed on now is just think of it this way. If you zoom out a little bit, a lot of you have probably wondered why you're getting paid. You're going to the Social Security Administration building or the VOA building, and you're working right next to people that do essentially the same work that you do, but are getting paid more money. And that is what that is amounting to, is the fact that many of you were either for some of the Social Security folks, you worked for years with a blanket purchase agreement with the government, and they moved you over to individual contractors, or VOA, they worked here as 1099s for many, many years, and then moved you over into PSCs, or or you worked for a contractor, and the contractor placed you with the government, and then the government controlled how many hours you worked, where you worked, when, whether you got leave, and how much you got paid. So we're bringing those types of activities, while not necessarily a violation of the Fair Labor Standards Act, are a violation of nearly every state that I can find. And I've done a really thorough survey of every state in the union, and every state in the country has a law that says you can't treat employees like independent contractors. That's the subtext. Now the government will say, well, look, I didn't employ them. Somebody else did. Kamazi did, or Stratcom, or Techniarts, or whoever. And my response is, that's fine. Techniarts may have been the people writing their checks, but they didn't have any control over the employee as to when they worked and how much. The contracts were pretty much, from where I've sat and many years doing government contracting, the contractor is basically, at the behest of the government. The government will typically tell them, hey, I need 20 seats. They might say put out a bid and say, we need 20 people to work in this particular job, doing this particular thing. And then they'll tell the contractor, bid this at 1,887 hours a year. Figure out your hourly rate, bid it at 1,887, add on your expenses and your profit and profit margin, which is usually paper thin, 3 or 4%, and submit that to us for a bid. And of course, as you would anticipate, the company with the smallest margins is the company that wins. Right, because they're the ones that are, the pay is normally dictated by something like the Services Contract Act or some other act says this is what you have to pay these folks. Then you add on your tax and your whatever, and the amount of money that, and again, whoever bids the lowest margin is one who wins. The government then takes over once the employer places the human in the job, and then the government will require two things from the contractor. One, it will only allow the contractor, even though it's a firm fixed price contract, it will only allow the contractor to submit invoices for the actual number of hours worked. And then the second thing is, if the individual works over the 1,887 hours, which is not even full time, it's full time minus sick leave and vacation pay. And even though the Services Contract Act requires both sick pay and vacation pay, that leaves the contractor with inadequate amount of money to pay their employees when they work overtime. And of course, the employees sue the employer, but the employer ends up going out of business. And I've seen that happen, about a half dozen times. I've seen the employer either put completely out of business or very close to being put out of business. So, and the employees are the ones usually left holding the bag. So I'm going after the actual culprit, which is in this case the federal government, and we're going after. So we're gonna, and I'll show you guys what this looks like. What'll hit your inbox. But what you'll be, what we're going to do is, like, say, folks that live in Colorado, there's Colorado state laws that say you can't misclassify someone, and if you do, the damages aren't just lost overtime, lost minimum wage. It's what they had to pay in self-employment tax. It's what they had to pay for health care. It's what they had to pay in all these different things. And every state has a different statute, but in every state, there are damages associated with misclassifying employees and treating employees like 1099s. So that is what that's going to look like. Now I'm going to bring up, I'm going to pick on, go to my website that I've been doing all this on. And I'll show you guys what this is going to look like when it hits your inbox. Because again, like I said, 128 of you as of this morning have submitted completed forms. I'm going to put the form in the chat today for those who have not, and also because I'm going to send this thing around. But I need everyone, and I expect that the folks who are on this call are folks who have already done that work. But I need everyone to get this filled out, because unlike the case at the Court of Federal Claims, I actually need a Form 95 completed for every person who wants to engage in this case. I can't do a collective on the what's called the Federal Tort Claims Act. I can't do a collective on that like I can under the Fair Labor Standards Act. Hold on a second, Sue. I saw your hand was up. Let me show everybody what this is going to look like here in a minute. I don't want to share anybody's information that they should not have. I shouldn't. All right, 1 second. History. So while this is pulling up, I'll let you know that. So the other thing I'm going to be doing is opening up a data room for each of you. I did 55 of them yesterday. I'm going to get the rest of them done today or tomorrow. There'll be a data room open up for each individual. I'm going to copy what I already have, because some of you have already uploaded stuff to Clio. I'm going to move that into one of my software called Net Documents. I'm going to open up a portal for each one of you that you can literally just drag and drop every single thing that you've got on your computer into NetDocs, and that means every email, every document that you can go for as long as you can find it. And again, what I want to say to everybody is there's no pressure to find anything, but everything you find will end up in the ultimate complaint that gets filed. The actual document itself won't, but the the information from the documents will end up in the actual complaint that I file at the court. And these will each be filed in federal court. So Sue, your hand is up, so I'm gonna pick on you a little bit. When the government, when the Social Security Administration, denies, if it denies, and I expect that the agencies will take a hard stance on this and deny the claim. But if the agency denies the claim, and it could approve it, that would put the end of this. But if they deny the claim, then we'll go to federal court on it, and it'll go to yours. Will go to yours, and everybody else in Colorado will go to the U.S. District Court for the District of Colorado. But the remaining, we'll go, like some of you are in Texas. There's a bunch of you in, Maryland, Virginia, and DC. There's folks in California, Florida. California is a particularly toothy state to do this stuff in. So this is all in the name of weakening the government and hopefully getting them to a position where they are ready to, well, they're either ready to settle or they're forced to write a check by the courts. The other thing is that the groundwork that we've laid at the Court of Federal Claims, including the appeal that we currently have up, is going to do a lot to open the doors on this, and it will have established law that says that the statute of limitations, for example, is not run, because that'll be one of the defenses the government will go to. And the other thing, and I want to show this to you guys, but one of the other things that, and I got to be careful who I show because not everybody wants me to share all their information, but what will be different about this particular round of documents that's going to come to you guys is that it will not only show you, when you read the documents, you'll see the factual allegations. For a Form 95, when you see the federal government on this level, you have to list a sum certain. And I'll put this in the explanations when I send this to you guys, but it'll say, for example, the amount we're asking from the government is, 475,000 or 723,000 or whatever the number is. And I'll tell you again, I'll repeat this in the instructions when I send over, but it's important that you look at that number and that you be confident that that number is okay with you, that it would satisfy you as far as the amount of money that you feel like the government owes you. Because if the government says yes to that number, that puts an end to that case. It's like I said, it's not a high likelihood that they'll say yes, but if they do, that ends the case. You're basically accepting what the government offers you on that front. If they say no, or they come back, let's say we offer them 475 and they say, well, we'll pay 300,000. We'll have to bring that back to you and you can say yes or no to that number. But I don't have any authority to say, yeah, you should take this number. You're the only one who would have the authority to say yes to that. And if the government says yes to 300 instead of 475, that's still a rejection of our offer, and we can still go to court if we so choose. So the only thing that's really important is that you fact check the things that are in there, because again, there should be a direct, lift from the documents that you've submitted, but just make sure that I haven't typoed something or misstated something. And then the amount that we're asking for, make sure that you're okay with that number. Sue, while I'm waiting on my software to act, why don't you ask your question?
Joe, on the form, I tried to fill it out, and the section where it asks you the end date of employment, it says that you don't have to enter that, but I can't get past it without entering a date in there.
Just put today's date in there, and I'll know if I read that it's today's date that it means you're still working.
Okay.
Will it let you put something in there other than a number, like still working? Because I can go in and create. I'm the one who got to choose whether it's a mandatory field or not, but I could change it to a text field, and then you can put in still working. It's probably a date field right now, which is something I can fix if it's messing up. Or you could put in today's date, and I'll know that that's okay.
Okay.
I'll know that means you're still working there.
All right.
The one who's looking at all these forms, they're not like going into the ether or anything. I'm looking at all these forms, I'm pulling them in. I'm using these to create individual vaults for every one of you. This, unlike the case we have at the Court of Federal Claims, this is going to be like an individually styled case for each one of you. And your damages number is going to be up front, as opposed to like the Court of Federal Claims case. We're going to be basically waiting until we get all the evidence on overtime and minimum wage. This particular case is about the tort of misclassifying you, so it's a very different bucket of damages. But yeah, go ahead and put today's date in there, Sue, and that'll be fine,
Thank you.
of course. And then I got Mr. Distance, and I've got Miss McFagin. I think Miss McFagin had her hand up first.
Did you say distance?
No, I think, well, Mr. Distance, go ahead and go first. I couldn't see whose hand went up first. I'm just trying to be.
Okay, go ahead.
Yeah, go ahead. And go ahead and go, Mr. Distance, go ahead.
Okay, so my question is, so these two different suits, and I'm not sure if I'm in two different or it's just one. And I did not fill out the information because I wasn't sure if you wanted my entire federal government history of the different places I worked for under different contracting companies and as a POV. So it's a long range for me. So I just wanted to make sure where the dates of this would be.
I'm so glad you asked that question. I'm trying to let you finish, but I'm also like really anxious to answer that question because you bring up a super solid point that I should have included in the instructions. I want a different form. I don't necessarily need a different form for every government contractor that you work for, but I do want a different form for every agency you work for because the Form 95 has to be served on the agency that, let's say, just broke the law. And I don't care how far back you go, because again, I'm trying to convince the court that the government, the term is, I hate using these terms because these are legal terms, but I'm using the argument that the government is equitably stopped from arguing a statute of limitations because the DOJ has taken the position that you couldn't be misclassified, that the government couldn't violate these laws. So I'm arguing that, look, they don't get to pounce on the 2 or 3 year statute of limitations when they basically flat lied to you. So, Mr. Distance, the answer to your question, to be unequivocal, is fill out a new form, and don't worry that it has like all of your other information in it like that. That's fine. I'm smart enough to figure that out. But for every agency that you work for, then go ahead and fill that in, fill out a new form for that, because that's going to be Jason Lambro, who's on, I feel free to talk about him because he was the named plaintiff on the first case, and he and I talk all the time. He's going to have at least 3 different claims. He's got State Department, DOJ, and VOA.
Right.
And there'll be others like him in that group.
Okay. Yeah. Okay. That's great. Thank you.
Of course. Yeah. Thank you so much for asking that question, Mr. Distance. And I think we had Miss McFadden. I'm doing a terrible job.
McFadden. You can call me Rochelle. It's McFadden.
Thank you for putting me off the hook on that.
That's okay. Two things. I just wanted to make a statement. When I filled the form out in date, I put January 1st, 2025, because that was the day they shut down. I know it was in January when new administration came in.
Yes, ma'am.
So I just put January 1st, 2025.
That's fine. I think they actually ultimately gave you guys, that's when they gave you notice, and I think they let a bunch go in May, and now there's a new court case. And that's going to be a whole retaliation claim. So the other thing that I want you guys to remember, and I'd like to hear from somebody, has anybody tried to re-access the form that you've already submitted? I'd be curious if anybody tried to do that, because I want to see if there's a way for you guys to update or have to fill out new forms, because I really want you guys to pay attention to that paragraph section at the end. That's kind of a like let it all loose paragraph. Like tell me anything and everything that you can think of that you think might be valuable. I'm going to be the only one that sees that form. The actual affidavit that comes after that, you'll see it, you'll fact check it, you'll sign it. Does that make sense?
Okay. Yes, but I had another.
There'll be a different
question.
affidavit. There'll be a different affidavit for each. Like for Mr. Distance, he'll have a separate affidavit for each company that he worked for, or not each company. I keep saying company, each agency that he worked for. So if he worked for state, and he worked for DOJ, and he worked for VOA, and he worked for USPS, there'll be. And I said USPS because Marie just joined us. She's one of my USPS people. I got a few more people to let in. Hold on, here, folks. There's Marie. Yeah. All right.
I had another.
Go ahead, Michelle. What's your other question?
Okay, so filling out the form on page 5. I'm sorry, page 5. I would like to talk to you offline about that, like when you leave.
Yeah, 100%. So you should have gotten a text, Rochelle. You should have gotten a text message from me during the week. It was from me, but Mrs. Whitcomb Selinsky. She actually works for the company. She's my wife. Her name is Carolee. She sent you a text that gave you the link to get to the form. You may have gotten it from an email from me, or you may have gotten a text message online. That text message, for everyone who's listening, that text is directly to your case in my system. So it's like your own little pipeline directly to me. And anybody else's work. So there's no way you can miss it. So if you want to, and there's a client portal. So anything you want to, if you want to request a meeting, for example, any email you've ever gotten from me, including all the emails, I'm gonna, you guys are gonna punish me for telling you this, but even the emails that I send you through my marketing software that like reminds you of this meeting we're having today, every one of those software has a meeting link. So you can, it automatically schedules you for half an hour. Now, if I start seeing that like 80 of you schedule a meeting with me because you all have different questions, then I'll just do one of these again. And I'm going to keep the tempo of these are going to pick back up. I wasn't ignoring you guys. There was a big appeal brief that I had to get done at the Court of Appeals, and that was filed on March 20th. I should say, when you guys look at it one day, you'll call me a liar. It was the early morning, like 1 a.m. on the 21st, that I filed that because I got on a plane that morning at 6 to go on spring break with my kids. So that it wasn't due until Monday, but I wanted it filed before I didn't know what my internet connection was going to look like. But I had that. It's a 60-page brief I had to file as Court of Appeals, having to do with, like, again, getting as many of you into this case as humanly possible. I'm also going to use these forms that you guys have created to add yet another amended complaint to either the Lambro or the Jordan case because when Summers dismissed the last case, he dismissed like all my VOA people, but I've still got, I don't know, 150 VOA people that had opted in before the dismissal. So I'm just going to file new complaints in their name because they're opted in plenty of time. So he didn't deal with them. He didn't dismiss any of those with or without prejudice. And I'll just go file new claims. And now these forms that you guys I can't tell you how much useful information that I'm getting right now. I mean, I want you, that's why I'm like, I'll tell you guys, and it's only going to take 5 minutes. If it takes you 15 or 20 and you really give me where all the bodies are buried, that is great for me. That is great for you guys. That helps me put together a very robust case. And then again, I'm going to pull all of this stuff into a portal, right? For each of you individually. Like, Rochelle, you're going to get an individual portal. I'm going to give you instructions and say, look, I'm going to ask you to go grab every email. And you're like, oh, Joe, that's too much. It's not. I got plenty of software to handle this stuff. So every email, every document related to your employment, every agency, Mr. Distance, every agency, every company that you work for, you can pull paycheck stub, you can pull invoices, all of it. Because again, I'm going to end up in a discovery fight with the government eventually anyway, and all of this stuff's going to have to come out. The more I have of it in advance, great, the better. But also the more stuff that the more ways that I can actually get specific in the ways that the government shorted you in advance, the better off this case, the stronger this case is right out of the gate. Michelle, did that help at all?
Well, question is, the form that you sent me, I'm under the retaliation,
Yep.
I guess. So do I still fill this form out?
Yeah, I want you to fill out the form because the other thing is, I don't have a sworn affidavit from you as it relates to the FTCA claim. And so I want these forms filled out by everybody I can get them filled out by. Every single human.
Okay. So I had a question on a section on the form. So can I ask you after the meeting is over?
Sure, of course. Yep, you can ask me in the meeting. You shoot me an email. You can shoot me a text back, and I'll respond back to you.
Okay, thank you.
Of course. Mm-hmm. I do not know who. Let me see. I don't know whose hand was up first. Okay, looks like Ruzbeth Olhari. Hopefully, I didn't do too bad a job on that.
Hi to you and everyone. I completed the form that was sent by you last week, but I received another email from you last night,
Yes.
and I was asked to complete it again. Should
No.
I do that?
No. So the email says, if I didn't mistype, the email should say, in the event that now, did you get a text from me directly saying you to please, because there may have been some information missing, but I don't remember your name. There was only two that I remember that had, there was like missing last name information, but yours does not seem like that. So that would have been the only, and if I need you to fill the form out again, I'm not going to send it out in a blanket email. I'm going to send you a text directly through the system. All right. And I
see.
wouldn't ask you to say, I wouldn't say, just do it again. I would never do that to you. Okay. That would just be me.
Okay.
I would say, Mr. Bahari, your address is missing information. Could you please go in and fill the address out or something like that? I wouldn't just hit you with, hey.
So I shouldn't complete it again.
No, sir. No, you should not repeat it. You should never complete it again unless you fall into the category like Mr. Distance and others might, where you work for multiple federal agencies over the years. But I think you're going to tell me you're one of my USAGM folks, right?
Yes, actually, I worked for VOA from March 2023. But before that, I started my job under government umbrella in RFERL, Radio Free Europe, Radio Liberty, from 2006. So I almost worked there. And last time I asked you and you answered me that the RFERL is included in this case.
It is. But you can go back. Listen, I don't want you guys to edit yourselves. So don't think, well, I had a guy who wrote me and said, like, I'm not going to really qualify. Like, let me be the legal authority on whether you qualify or not. And don't say, oh, well, this is too far back. Don't do that. Just if you give me too much information, I'm perfectly capable of whittling it down to the information that matters. If you don't give me enough information, I'm going to have a harder time guessing. And we're going to go through this, but by the way, like, we're about 252 people that are currently in the case in DC. That number, ladies and gentlemen, is probably going to eventually expand into the thousands because of the way this case is styled. But while we're still small, I am reaching out to you individually, and I will always reach out to you individually. It may not just be me. It may be, me and people who work for me, but we're going to build these cases up individually, because what I'm trying this is not, and I explain this on a regular basis, but it's worth explaining again. This is not like what you would, if you guys have seen on TV or maybe seen something in your mail that says, hey, your Ford Motor Company made a bad tire, and if you want your $100 out of that case, do nothing and you'll get a check for $100, right? Or this is not like that. This case is styled so that every person gets a calculated amount of damages. Like at the Federal Tort Claims Act, the FTCA Act that we're working on now, and the case that we have at the Court of Federal Claims, they're not allowed to be class actions. I have to file a Form 95 for each and every claimant that's suing the government, because there's a requirement. And many of you work, I know, like Sue and Steve, you guys work in administrative law, so you get this. If there is an administrative finality requirement in these cases, so I can't go to the federal courts until I give the government the opportunity to, right their ship, so to speak.
Mm-hmm.
So you're in good shape.
My question is related to another question. I was asked for the first page of the form, I was asked where I worked. Yes. I mentioned that I worked for VOA and also for RFERL. And the other pages just focused on the last place that I worked. I mean, the VOA.
That goes back to the information I gave Mr. Distance. So this is the only reason you would have to file a second form. I do need a form for every federal agency you work for, because I actually have to sue that individual agency separately. So what's unusual about your situation is that USAGM is actually owned by the State Department.
Yes.
Right. And I think so is our RPI, right? It's probably state also. But yes. I serve it on the individual agencies. So if you work for 4 agencies, I'm going to need 4 forms. Now, the lion's share of that information will be copy and paste, but the individual infractions that each agency did, I'm going to need more information on that, right? And if you had, like, let's say you had you had a gap in service. Let's say you worked for the agency from 21 to 25, and they did something bad in that 21 to 25 era. That might be one form, and a second form might be a time from like 16 to 20, something like that. I don't worry about I guess basically just use the number of forms that it takes to get all of your information to me, because these forms are free. I'm not getting charged per form. Everything you give me is going into your individualized vault and your individualized data room. And you're going to maybe copy and paste documents all over to this. And I'm not going to make you be my legal secretary. I'm not going to make you do any legal work for me. You just drag and drop this stuff and I'll sort it and figure it out.
Mhm.
So
at the first actions, I sent all of the information about what I worked, 2 places, and the conditions and injustice behavior by the management or the companies. So it was enough, actually.
sure, that's
because
great. So
I sent it before.
Yep. So here's the thing, Ms. Mahar. All of it's going to end up in an affidavit, and you and I will get to work individually on it. It could end up being 2 affidavits, but that's fine. We'll end up with all together, because again, I might have to serve it on 2 different agencies, but you and I will work on that end of it. This is not like one of those fire and forget situations. This is the beginning, not the end of this process. So you get this into me, I'm going to pull it into an affidavit, and then we're going to have a bunch of individual. I'll send it to you to review in a Word document. You'll say, yeah, this is right. It's not this. You can tell me your comments on what we need to fix,
Thank you.
and we'll get it submitted after. That's why I'm giving myself till like the end of this month to get all of that done. It's not going to.
Thank you, because
do by the end of the month.
thank you, because I wasn't not the only person that I have this question, because some colleagues or ex-colleagues contacted me and they asked about it. I told them I will ask and I will answer you back.
No, I
So
appreciate
thank
that.
you.
And one
Thank
of the
you so
things,
much.
so as soon as we're done, that's what the other thing is. That's one of the values of this. One of the benefits of this type of webinar is, like, a lot of you will have this kind of question. I'm going to send out the link to this webinar around to the whole group, right? And then they'll hopefully be able to watch it and learn from that.
Okay. Thank you so much
Mr. Green,
for your
you're up
time.
next. What's up? Russell, you're still muted, brother, if you need to unmute.
All right, Joe, can you hear me now?
I can, Mr. Russell. What's going on?
So basically, my bad, I missed the last few meetings. My only question is, could you elaborate on 2 things? The dismissal of the Green Jordan case, as far as the statute of limitations. That's pretty much one question. How does the dismissal of our case affect the statute of limitations?
All right, so Russell, your case, I don't know if you heard me talking at the beginning of this. Yours is what's up on appeal right now. So
Okay.
so they dismissed it on what's called a Rule 54B. So we normally, when a part of a case gets dismissed, I have to wait till the whole thing is done and then go up on appeal. I asked the court, and they granted that they dismissed you and Marie and the others for different reasons under for statute of limitations reason. One, first of all, Russell, he got it just flatly wrong, because he's under the impression, and this is what I've explained it to the court in an exhausting number of documents, but he's under the impression that the misclassification is the government's sin. I explained to them in the response to the government's motion to dismiss, the misclassification isn't the primary sin. The primary sin is failing to pay you overtime and minimum wage. I only argued misclassification because that's the only grounds under which you'd be eligible for overtime and minimum wage. So Summers is super confused, but the case is fully briefed on my part. Well, I filed my opening brief on March 21st. You, Michael, Jason, for retaliate, because he also said he didn't have authority to decide the retaliation claim, which I of course know is bizarre. So all of that is currently in front of the Court of Appeals for the Federal Circuit again. This will be the second time we get this case remanded. But the very good news for everybody, in my estimation, is this. If the Court of Appeals decides this case the way I believe they will, right, which is to decide that, the statute didn't run for all the reasons that I've argued, which includes, most importantly, the collateral estoppel argument that the government doesn't get to claim statute of limitations when its last argument was the benefits don't exist in the first place. So we've got all that in front of the Court of Appeals Federal Circuit. The other piece is this case, this parallel case we're doing. So to answer your question, Russell, as it relates to all the, first of all, he just ignored the fact that you and Mr. Jordan still work at VOA, or did until the layoff, if you guys aren't back. He's also, I think he operated, maybe correctly or incorrectly, that everybody was moved at once into PSC positions, which I think is not true. And there's no reading my documents to suggest that everybody was categorically moved into W-2 positions. But even being moved into W-2 positions, there are many of you that we've learned were still not paid overtime, or were instructed to get comp time instead of overtime after you move to the PSC position, which is, again, flatly illegal. So we're still very much alive on that front. So that's the long-winded way of saying that. You're still very much alive. Did you have a second part to your question?
No, that was it. That's it. Thank you.
Of course. All right. Let's see. Next below is Nazanin Stefan.
Hi, Joe. Yes, the form that you emailed us and also text us, I thought that you needed by today, so I kind of rushed into it. If I want to update and add more stuff, can I just do it do another form?
Yeah,
or
you
should I-
absolutely. So you could do an experiment for me on one front. I'm curious to know whether or not you can once you've hit submit, if you can re-access that form. I just don't know. I've never been on the receiving end of these forms. But the second question is, like, you fill out, I don't want to say fill out as many as you want, because somebody will fill out 10. But if you need to redo it, take another swing at that form. This is for my consumption only. I'm pulling everything, and I'm going to drop, by the way, I'm going to drop the link to this form into this chat right now, so that anybody who is on this call and hasn't completed it, or feels like they need to go back and do it again, can. And so what's really cool about the output on this thing is that it'll say PDF number 75 or 100, and it'll have your name on it, right? So if you did 10, I would just pull them all into the same vault, and don't do 10 unless you have to. I pull them all into the same vault, into the same, because I'm using some really sophisticated AI. It's all legal based. It's super expensive. It's really, really comprehensive. And it's got a big moat around it, so nobody can see it but me and the people I share it with internally in my building. But it's taking all that information and consolidating it into one document, and you'll be able to see, like I said, everything that you put down. It'll create, like I said, one affidavit. And like I said, if you work for multiple agencies, certainly fill out multiple forms fill out a form for each agency. But if you needed to redo it again, please do. I just dropped the link to the form in the chat. So if you haven't already completed it, please do. If you feel like you missed information, a duplicate form won't hurt me, because again, each one of them is labeled by name.
Okay, the problem is that with form, some of the questions, they're check mark. You can answer, you can pick multiple answers, but some of them you can only pick one. And for those, like I started as a POV, and then Technologists Inc. hired us. And then after that, I was a PSC with Voice of America. So I had 1099, then I had W-2, and then another W-2. So
So the whole time you were W-2, you could, what I care about there is like the benefits you didn't receive, right? Especially that's another place to sort of double down on overtime and minimum wage. And the stuff that I'm really interested in there is the instances in which your employer, because I've interviewed many people who worked at VOA, and several have told me that their employer, there's two things that I've seen over and over again. One, their supervisor saying, don't put in for overtime. If you work overtime, take a comp day. I want to hear about that if that's happened to you, because that's illegal. The second one, which is one lady explained to me in real detail, there was a bunch of people that were told they had to be on call on the weekends, and they had to basically volunteer to be on call. They weren't paid while they were on call, and that's also illegal. You have to be paid while you're on call. If you're giving up your time and living by your phone and not going to happy hour, not going to dinner or whatever because you're on call, the government owes you money for that.
Yes, actually, that's one of the things I forgot to mention. That happened to me too. I was on call without pay.
Yep, that's in a lot of, that was on 1099 and in the current FTCA contract.
So, that actually was recently during the Israel and Gaza war. It was like that during that time that we were on call, and we didn't get paid, and I was on W-2. So that's why I didn't know which one to pick. I picked 1099, and I explained in the in the box that how it worked, because I had basically three forms of employment.
Sure. There's also that final, I went in after I sent it out, probably 30 or so people had filled it out. I went back in and I edited the form again and added a sort of a paragraph at the very end that's supposed to be like a catch-all. Yes. And there's no limit on that. You can add as much as you want in there, and you could kind of tell your whole story. Anything where the form doesn't have enough information, just put it in there, and again, it'll all get pulled into the affidavit.
Okay, great. Thank you so much.
Of course. I have got Steve Justice.
Good morning, Joe.
How are you, brother?
I'm good. Hey, I'm still having problems with the email. I'm not getting emails or text messages. Sue is forwarding hers to me.
Let me see. Like, I'm in Clio right now. The email issue I don't seem to be smart enough to figure out, but I can certainly fix the text thing. I should have the right phone number, and I don't want you to give your whole phone number. I don't want you to give your phone number all the way on this call. You probably get, I don't think anybody in here would prank you, but if you're like me, you probably get 25 offers a day to refinance your house. And I don't want to necessarily give end up with more of that stuff coming in. I don't know when my house became so popular. I'm going to send out a text to you guys directly that I have in the system, Steve. And if it's just going to Sue, if I've got both numbers, like for example, if I've got both, and I've got, because you and Sue, for those who don't know, they both work in the same building for the same outfit. So let me go in here and take a look at this, because what I suspect happened is that I've got both of the entries with the same phone number, and I'll send one out today. And then if it's got the wrong number, then Sue can respond back if it's going to the same thing. I'm going to send one right now, and you guys can tell me if it's going to the wrong number. Because I'm in your if it's got the wrong number, if it's going to Sue's phone, just respond back with Steve's number, and I can change it in the system. I've got the email right. I'll put that email in the text also and make sure that that's right, because that could be somebody like me might have accidentally fat fingered the email address. That could be me. So so I'll make sure that's fixed. I just set the email and the text to the number I have on file, and if anything's incorrect, just have if it's going to Sue's number, for example, have her respond back with the right phone number and the right email, and I'll get that fixed. That would be the only intelligent explanation I could come up with for that.
All right, thank you.
Of course. And then Ngidu.
I didn't get either.
Yes, sir. Thank you.
Did you get
so the state-based claims, you have examples of things like non-payment of sick and vacation pay, failure to pay benefits, failure to pay FICA or Social Security, etc.
Sure.
As a PSC, I know people before the PSC program face a different situation, but as a PSC, I got all these examples of things the FICA taxes and the vacation and PTO and sick leave. So if the state-based claims are mainly about these, it will be suing the government for the benefits that I already received, unless there is something else in the.
Well, no. Listen. So you will have two cases going in parallel, and I have designed this form to help both cases. Okay, I'm just using the state. So, for example, you I know for sure are not a named plaintiff in my FLSA claim at the Court of Federal Claims. That's where your overtime and minimum wage stuff comes into. So again, don't just give me all of the infractions that you believe are happening, like your overtime minimum wage. If you had a backstory where you were working as a 1099 before, like many of the people at VOA were working as 1099s before they transitioned over to PSCs, let me know about that, right? Because again, I am very interested. So I want to get you all the money you're due. I want to get you money for if they misclassified you. I want to get you money if they failed to pay your overtime, minimum wage. There are folks who were like working for Social Security, for example, who were W-2 employees for the company they were working for, but the agency refused to pay them travel pay when they would drive, hours, 2-3 hours, or whatever else. I talked to Jason gave an example of like having to buy his own plane tickets and not getting what's the I want to say Avalon, but it's not Avalon. The per diem pay when they were traveling. Anytime you did work and weren't paid for it, anytime I want to know about all of them, right? Anytime that you were told to be on call, that I want to know about it, because what we'll find, right, is that there's very often overlap. So it could be a state-based claim also that where you weren't paid overtime, so there's a lot of times there's state-based claims, state-based torts that overlap with the federal torts. So the ones that I enumerated, and thank you for bringing that to my attention, the ones that I enumerated were the ones that were not covered by the Fair Labor Standards Act. FLSA does not cover things like sick leave, vacation pay. It doesn't cover those things. But many of the state statutes do cover what FLSA covers, do cover overtime and minimum wage. The other one is like uncompensated expenses. That's very often covered by state-based claims. What the guys that I'm co-counseling with, the Forrester Haney guys, they made their first big hit on Domino's, because the Domino's employees weren't getting paid for the proper. Domino's just decided to pay them whatever they wanted to on mileage, when there's a federal statute that says this is how much you have to pay, or maybe there was a state-based statute that says this is how much you have to pay people when they drive, and they didn't do that. So if it occurs and what I tell most people is like, look, if you heard about it and it seemed uncool when you heard about it, tell me about it. I want to know about it. I will find if it's a legal infraction, I'll find it. Okay, I'll figure out what it costs. But like I said, this on-call thing, that's a big deal. And again, it could serve me in the federal case we already have going on, because again, the government we're about to enter the discovery phase of that case, and I'm about to file an amended complaint in that case that goes back to what Mr. Green was asking before, this dismissal. I'm going to go back to that case and add a bunch of VOA people that have opted in since July of 24, right? That they've already made their voice known, and these affidavits will help me sew that up. Even going back to Russell and Michael, there were some things that the court assumed when it made the dismissal that were just untrue. And by the way, they had affidavits on place that said they're still working there, and the affidavit said as much. But Summers is he's not really paying as close attention as I wish he were. So fill the form out. I will find a way to use it. I can't have too much information.
Sure. So the state-based claims also covers the non-payment of overtime. Is that?
That's right. That's right.
Okay,
Okay.
I'll go through the form, sir.
And varying states, just so you understand, so the FLSA statute. Here's a really important segue from the question you just asked. So the Fair Labor Standards Act says, hey, employer, you owe for the last 2 years, or 3 if we show it's intentional, times 1x times, if you show it's intentional and they shorted you $10,000, you owe 20, and you owe attorney's fees. Some of the state statutes have minimum per violation damages. So you could have 20 violations that are worth $5,000 a piece. And the software that I'm using is connected directly to the statutes and the case law, and it will tell me exactly. That's one of the things that's different too, is it'll have an actual computation as to the amount of money the government owes you, and that'll give you guys a picture of like what we're asking the government for, down to the penny.
Sure. Thank you, sir.
All right, let me see who else I got. Let me see if I got any more hands raised. That was you in do, right?
Yes, that was me.
Okay, and then I got Ignatius. Did I say that right? Ignatius Anor?
You're right, Joseph. Can you hear me?
I can.
So thank you. My apologies to you and everyone on the call, but I missed a chunk of your submission. Is there any new update that you wanted to share with us aside of asking us to fill the misclassification form?
So first, the answer to the first part of your question is I've had this is being recorded and transcribed. So I'm going to send that around. It'll come to me. It'll hit my inbox within the first hour. I'll probably send out that email. Usually my habit is to send it out near the end of the day. And it'll have a recording for this entire meeting, and it's password protected. The password will be in the email. So that's the first. So yes, this is about the state-based claims. You just heard me explain that in some detail with the last speaker, and this is to cover all of the things. These are going to be, so the way this works again, it's just going to be a Form 95. It's a standard Form 95, along with your affidavit and statement and calculation of damages, is going to go to the state agency. Each state agency will get, I expect like VOA will get 180 of these things, and State Department may get 12, and Social Security may get 100, and again, as you guys get the word out, because right now, like everybody who's in this case we haven't had a lick of discovery yet. So everybody who's currently in this case has come into this case word of mouth. Everybody who's come in this case, every one of the I have about 400 people on my email server list right now. 250 have actually opted in, and I'm hoping that more will opt in as a result of this round of questionnaires. But yeah, I've got an appeal up at the Court of Appeals federal statute for the Federal Circuit. I've got discovery starting in both Lambro and Jordan. There's been a replacement of counsel from the DOJ. It was Matthew Carhart has been on this case since 2020, and he was only on Lambro. Now he's on both cases, Lambro and Jordan. So, and right now we're doing everything we can just to keep the government's feet to the fire, and these forms help me do that because again, they really bolster the allegations that we're making.
Thanks, Joseph.
Of course. Ms. Beasley.
Hey, how you doing?
Great, how are you?
So I wanted to say first, the form, you can reassess it or reaccess it and fill it out again because I actually did. So.
All right, but you can do a new one as many times as you want, right?
Right. Yeah.
Yeah. I hate that that's the case, and I've been using this software for about a year, but I typically have a tech person who helps me with stuff like this. I really like the software. I've built this entire form in Google Forms and then imported it into Cognito, which is the software service that we're doing this, because it syncs directly with my case management software. But there are some things I wish it did better. But if you feel like I said, if you fill out a second form, like I said, I won't have multiple submissions per person. Again, it's all going to get pulled in your individual vault. I'm going to open up, again, that's one of the things I want to make sure you guys hear me say. I'm going to open up a vault in a product called Net Documents. I'm going to send all you have to do is hit forgot password. And I'll make sure you have instructions on that. Hit the forgot password. It'll give you a password reset. then you'll be able to drag and drop as many documents, emails, anything that you want to drag in there. You cannot, I have so much space in there, you can't overwhelm it. And it'll have each person now, because right now everything has been sort of in one box as it relates to the one case. Now we're going from one case to what'll end up being not, I won't say 250 different cases, but it'll end up being probably 12 different cases in 12 different states. And they'll be at the U.S. District Court for each of those different states. So Texas has got a big presence for me now with clients. Colorado, a big Washington, D.C., Maryland presence. I've got a few folks out in California, which is great. I've got California lawyers. So we're really going to keep the government on their toes with this. So again, filling out multiple forms does not hurt me a bit. I don't love that you guys are having to do it, but if you guys have the patience of doing it, I'll put it to use.
Yeah, so I was going to just say, yeah, you can access the one you already filled out, but you can submit a new one.
And when you start to submit a new one, does it populate any previously populated fields?
No,
it just starts.
it did not.
That sucks. All right, I'll figure out if I can figure out a way to fix that. I'll let everybody know by tonight. But right now, you and I are about as smart, both equally smart on this form. All right, but it does give me a PDF, a great little cool little PDF that I can download, and then my AI software goes to work on this. And you're going to really like the product you guys see when I send it out to you. And I'll send it to you guys the way I've been sending most things. It'll go through Clio, through the Dropbox hello sign, and you'll be able to read it, download it. You can download if you want to read it, print it or whatever, if you're still using printers, or you can just sign it right there, and it'll come back to me. And then, like I said, I'm hoping to get these things filed by the end of April. That's the goal I'm really pushing hard for. First part of May, I'd forgive myself, but I'd really like to get it done by the end of April.
Okay. My other question was, since I've been with you for a couple of years, like I've submitted things over time. Would that all be in that vault that you're speaking of? Okay, because I was like, I don't want to say the same thing that I've already said already.
Yeah, it's all everything you put on HubSpot, everything you put in Clio, everything you put on this vault, it's all going into one vault, and then I'm going to pull it into a product I use, the AI legal AI software. Pull it in there, and it's every one of you is going to have your own little vault. All right.
Okay.
And
okay.
When that complaint that I draft is going to be Beasley specific.
Got it. And then lastly, I just wanted to piggyback off what you were saying. For instance, so I work for ODAR. And so, of course, we didn't get paid for travel. But for instance, they wanted you to kind of add that in your bid. And of course, most people don't know what to bid, right? So
how are you going to know how much you're going to travel before you travel?
Exactly. So it's like you may make one price for Dallas. I live in Dallas. But if I went to Paris, Texas, which is an hour, and a half or so away, I would put, $70, because I'm hoping, I'll get that. But then you could get there and then no one shows up or only two people show up, and that doesn't cover travel. Right.
Yeah, you get $5 and no travel. Right. Exactly. So all of that stuff, I want to know all of it. The more the merrier. And like I said, that last paragraph, you could write a doctoral thesis and it'll never cut you off. So there's no limit on that. So put as much information in there as you can think of. And then again, that's just for the affidavit. When I open up that portal, you can literally you could drop your GPS tracking for all the stuff you did. Like you can go into your phone tracking and see all the travel that you did and document it that way, or you'll have your schedule, and every time.
Yeah, that's what I uploaded before was schedules and emails and stuff like that.
If you uploaded that, that's living in Clio. I'm going to download all of that in Clio and NetDocs Sync anyway. So all that's going to end up in your portal, and all of that stuff is going to go into your final complaint that I file at the federal court.
Okay. And lastly, I just want to know with this count too. So I know you were saying that you're supposed to be accounted for like sick time and vacation time.
Yep.
And of course, like you said, they set the schedule. So for instance, even if you said, hey, I have a docket, for March, blah, 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 and it's for the whole week. If I say I can't do Monday or Tuesday, be like, well, if you can't do the whole week, then we have to just take you off.
Yeah,
and you're like, well, damn.
That's right. That's like that. I want to know because again, I promise you, a lot of that stuff is going to be violative of that's going to be violative of the state law. Again, FLSA is very narrow. Fair Labor Standards Act is very powerful, but it's very narrow. It's just related to sick time, or not sick time, it's just related to minimum wage and overtime. These state-based claims are, the states go crazy because they're protecting their workers, right? So the states want, even Texas, I mean, like, state's a deeply red state, but it does a very good job protecting its workers, which I appreciate. So anything you can put in there, I'm going to pull it into the complaint. And again, I'm going to, look, hopefully the agency grows a brain and realizes that the fastest, the shortest distance between 2 points is still a straight line. And they got to write people a check if they, and I explained this to the DOJ the last time we talked. Matthew Carter and I spoke a month ago, and I'm like, look, man, because he was trying to make a settlement offer as just a Jason, and it was a low ball, sickeningly stupid offer. And I'm like, if you really want this case to go away, man, you guys are going to have to open up the checkbook. I mean, there's probably a number that you could make an offer and take it away from me, because the clients all have the authority to settle this claim. I don't, but my clients aren't going to be tempted to settle for $2,000. So don't make a dumb offer. So I'm trying to build this thing up as much as I can, and these forms go an enormous distance in helping me do that. Does that help you with everything, Ms. Beeson?
Oh, yes.
All right.
Thank you so much.
Let's see what Mr. Goldstraw has for us.
Well, Mr. Goldstraw is my first. We have spoken once, Joe. I feel like it's been very interesting listening to other people's questions. But when I completed the form, the one you sent out by text, and I submitted it, as you may or may not remember, Joe, I have a decade's worth of invoices and timesheets as a 1099 with the U.S. Department of Labor, with overtime logged but not paid as overtime as a 1099. All of that was put into the hands over a year and a half ago with Forrester Haney.
Yep.
Now my understanding is all of those approaching 100 documents are in your hands.
Yes, sir.
That's the first question. But the second thing is, when I was completing the form in advance of this call, I just kept thinking, as I answered each question, it seemed to me that, in fact, I was an independent contractor. I was not told when and where to be. In other words, I was not treated. I was treated for what I perceive myself to be, an independent contractor. That I'm not sure precisely how that works in my favor, other than as it relates to the matter of never being, like, some months I would work 160 hours often, but there were many where I worked in excess of 200. In other words, overtime theoretically could have been in place. But nevertheless, I feel like if I was in fact an independent contractor, not controlled by the Department of Labor or the company that paid me to perform the services, how do I have a case?
All right, so that's an excellent question. So you've talked about basically 2 prongs of a 7-prong test. So the independent nature is an element. The other is the investment. One of the biggest is your opportunity to scale. What I tell people, your opportunity to entrepreneur, right? So if you're an independent contractor is for all intents and purposes is a business owner. Right. And whether we're talking about the individual who comes by to build my deck, like I don't know if you guys have seen this app, but I've used TaskRabbit to have folks come out and do spot painting on or tear up floors. And that individual, when he's answering an app in the gig economy, he comes out and does what he wants, and he leaves, and I pay him. And I don't have any control of when he comes there or when he leaves. And also he can bring 20 people to do the work, right? And do 10 jobs a day, an entrepreneur, right? What I suspect is true is that the government, when the government sent you something to do, they expected you to do it, right? You weren't allowed to send your surrogate to go do the work, right?
No, I and only I was the person.
Exactly. That's right.
Yeah, and I did want to add, there was stated by the company that paid me that I certainly had, if I so chose, the ability to branch out, if you will, and perform services for other entities while delivering services to the Department of Labor. But of course, there was no time. There was no ability to do that just because I couldn't work 300 hours a month. So.
That's right. So now you've just intelligently articulated why you fit into the case, because you didn't have the opportunity to entrepreneur, because they required you to do that. It's the same thing with the VOA folks. These VOA folks will quickly volunteer. Well, look, they didn't say I couldn't go be an editor somewhere else. Like, that's great. That means that they get one checkbox. Right? But it's a seven to 9 prong test. And the one the courts pay the most attention to is, could you have benefited from efficiencies? In other words, could you have brought in 4 people that were lower paid people than you, that were willing to do the work for less money than you were willing to do it for? And you couldn't, because they were basically paying for the real estate between your ears.
I was in fact named in the IDIQ and the proposed contracts as a way of acquiring the contract. So I would never be permitted to have, as you mentioned, the TaskRabbit approach of maybe have 5 people working for me, so to speak. It was only I was permitted.
That's right. Now your boss, the person who was actually, or I say your boss, the contractor who placed the contract, they could have 10. They could have an IDIQ with 20 agencies and fill them with different bobs, so to speak, right? And in their instance, they were given the opportunity to entrepreneur, and they were actually running their own business. But the other prongs that it sounds like you definitely satisfy is the longevity of the work and the fact that it basically amounted to full-time work.
The work was in excess of a decade, and for the same company and the same government agency. And
they didn't pay you.
I worked on 6 projects.
Yeah, they didn't pay you the 7 points. They didn't match your. It doesn't sound like they matched your 7.65. Doesn't sound like they gave you any opportunity for sick.
No.
And minimum, they didn't give you any sick or paid leave, and those are all violative of state law in every state that I'm aware of.
Okay, that helps a lot. Thank you.
Of course. Hey guys, I don't see any more raised hands. We're going to, again, I'm going to pick the tempo of this up. I'm going to record that. This is already being recorded. I'm going to send this around. Weirdly, I've got more meetings than I normally have on a Sunday. I've got another meeting in another hour. But I'm going to go grab some food. If there's any, again, I don't see any hands up. I'm going to send this around. Look for another invite for this coming out. If you haven't already completed the form, or you can think of a reason to recomplete the form, like Bob just mentioned, you work for 10 agencies, or you work for 10 years for the same agency, but if there were multiple agencies in there, add them. Rochelle, you have another question?
Yes, I sent you a text, but you just said you were gonna go get something to eat. I said I wanted to see you for a quick second offline.
Okay, well, I'll when I end this call, I'll reach back out to you, okay?
Okay, sounds great.
All right. Thank you, everybody.
Thank you.
Take care.
Thank you.
Now.
Bye.
Thank you.